This is Barry Zalma, Zalma on Insurance. I am an attorney who has retired from the practice of law and now spend my time as an insurance claims consultant and expert witness, an author and producer of these videos. On December 1, 2020, for 30 full days, ZALMA'S insurance fraud letter in Adobe PDF format is available at www.zalma.com. This will be issue 23 of volume 24. The issue will include, for example, an article on the fact that evidence of a prior fire is available to a prosecutor to prove fraud, and that an arson for profit conviction was affirmed by the United States Court of Appeal for the Fourth Circuit after a jury convicted James Lester of arson conspiracy, mail and wire fraud. Lester contended that the district court abused its discretion in admitting the evidence of a prior arson fire called the Wharncliffe Fire. The district court admitted the evidence as intrinsic to the charged crimes. Alternatively, the district court determined that the evidence was admissible pursuant to Federal Rule of Evidence 404B as probative of Lester's motive, knowledge, and intent. Lester challenged the district court's admission of the Wharncliffe Fire evidence as intrinsic to the fraud charges, and he argued that the story of the crime was complete in itself, and there was no need to introduce evidence of the earlier Wharncliffe Fire. Lester also argued that the prejudicial effect of the Wharncliffe Fire evidence substantially outweighed any probative value it may have had to prove the criminal nature of the fires that occurred at properties owned by the conspirators in fires called the Matoaka and the Ikes Fork Fire in West Virginia. The government contended that the district court properly admitted the Wharncliffe Fire evidence as direct evidence of the Matoaka and Ikes Fork schemes because the evidence was intrinsic to the charged conspiracies. Rule 404B applies only to evidence of other acts that are extrinsic to the one charged. Acts intrinsic to the alleged crime do not fall under Rule 404B's limitation on admissible evidence. Evidence is intrinsic if it is necessary to complete the story of the crime on trial. Other criminal acts are intrinsic when they are inextricably intertwined on both acts are part of a single criminal episode, or the other acts were necessary preliminaries to the crime charged. Such evidence is inextricably intertwined with the evidence regarding the charged offense if it forms an integral and natural part of the witness's accounts of the circumstances surrounding the offenses for which the defendant was indicted. The Fourth Circuit, therefore, concluded that the district court did not abuse its discretion in admitting the Wharncliffe Fire evidence as intrinsic to the charged conspiracies. This evidence laid the foundation for the arson and insurance fraud schemes, and it was necessary to complete the story of Lester's relationships with his co-conspirators. Moreover, the Wharncliffe Fire evidence was inextricably intertwined with the charged arson conspiracies because the Wharncliffe Fire was used as a playbook for the Matoaka and Ikes Fork fires. In fact, the Wharncliffe fire insurance claim contents list was overwhelmingly similar to those of the Mataoka and Ikes Fork fire claims. The district court's judgment was affirmed. And in the opinion of ZALMA'S insurance fraud letter, arson for profit is the most dangerous and vicious form of insurance fraud. Often firefighters or innocent neighbors are injured or killed by an arson fire. In this case, the defendant had tried fraud with a fire before working with co-conspirators to set 2 more fires, making claim for the destruction of the same property involved in the earlier fire. That fact made the evidence of the earlier fire, the Wharncliffe fire, inextricably intertwined with the fires for which he was tried and convicted. And all arson investigators should be aware of this use of evidence in any case, whether civil or criminal, in proving insurance fraud. ZALMA'S insurance fraud letter also covers the 2020 Canadian insurance fraud report that showed a 75% increased workload due to COVID, and 43% were forced to reduce costs, and 65% of insurers are focusing on digitizing their files. The Minnesota Fraud Bureau also reported that insurance fraud referrals were up in 2019 and are probably up even more for 2020, with the 5 largest areas of suspected fraud reported to the Fraud Bureau in Minnesota being automobile, health insurance, homeowners insurance, workers' compensation insurance, and agent and broker fraud. The types of criminal actions tracked by the Fraud Bureau include senior scams, identification theft, medical ID theft, fraudulent health insurance claims, etc. In total, the Fraud Bureau's investigation resulted in state and federal criminal charge filings that had a $29 million economic impact. Overall, case referrals increased 13% in 2019. The newsletter, ZALMA'S insurance fraud letter, also talked about a case where a podiatrist was jailed for participation in a kickback scheme because he prescribed compound medications solely for the purpose of obtaining kickbacks. Dr. Alap Shah was convicted of participating in a kickback scheme where he was paid for prescribing expensive compounded medications in United States of America versus Alap Shah, decided by the 11th Circuit Court of Appeal on November 24, 2020. Dr. Shah appealed the conviction, and both he and the government admitted there was an erroneous instruction to the jury. At the request of the government, the district court had instructed the jury that Dr. Shah violated the statute prohibiting kickbacks if one reason he accepted the payment was because it was in return for writing prescriptions. In his briefs, Shah argued that the district court erred and should have instructed the jury that the government was required to prove that his main or only reason for accepting the payment was because it was made in return for writing prescriptions. Both parties agreed at oral argument before the Court of Appeal that the jury instruction was erroneous and that the statute requires no proof of the defendant's motivation for accepting the illegal payment, so long as he accepts the key kickback knowingly and willfully. The issue presented to the 11th Circuit was whether the instruction prejudiced Mr. Shaw or Dr. Shaw. Dr. Shaw was a podiatrist in Columbus, Georgia. He sometimes prescribed compound medicines to his patients. Compounded medicines are custom-formulated drugs that vary from off-the-shelf drugs in strength, delivery method, or combinations. For example, a compounded medicine might be a cream that combines 3 pain-reducing drugs ordinarily produced in pill form at a lower strength than that available off the shelf. Specialized pharmacies produce compounded medicines which are more expensive than off-the-shelf prescription medications. A single tube of a compounded cream can cost $15,000 or more. Shaw and about 20 others participated in a kickback conspiracy that involved writing prescriptions for compounded drugs. Shaw's closing argument focused on mens rea, that is, the evil intent, and a good faith defense. He began by telling the jury that the case is about whether Dr. Shaw acted willfully. The jury convicted Shaw. The district court sentenced him to 36 months of incarceration on each count to run concurrently, and ordered him to pay $55,340 in restitution. The statute on which he was convicted says nothing about the defendant's motivation for accepting the payment. The text does not require proof of a defendant's purposes in soliciting or receiving a payment. The statute's key phrase, remuneration in return for writing TRICARE prescriptions, TRICARE being a federal employees and military benefits for military dependents, says nothing about the reasons the defendant accepted payment. Therefore, the 11th Circuit concluded that there's no reason to stretch that phrase into a description of the defendant's mental state. Congress specified the necessary mental state by requiring that the defendant must accept the payment knowingly and intentionally. This is a classic case of a convicted criminal claiming that his conviction should be reversed because of an erroneous instruction. The problem for Dr. Shaw was that the erroneous instruction placed a higher burden on the prosecution than a correct instruction. The jury convicted him because the government proved his criminal conduct beyond a reasonable doubt, even though the erroneous instruction made the job of proving the crime more difficult. No harm, no foul. He goes directly to jail and does not collect $200. ZALMA'S insurance fraud letter then publishes good news from the Coalition Against Insurance Fraud and their reports of convictions, has a listing of health insurance fraud convictions, which because of the COVID pandemic seem to be becoming less and less, although there's still plenty of convictions of doctors and healthcare professionals getting involved in crime. It talks about other insurance fraud convictions where people like a federal contractor was required to pay $18.98 million for making false claims. A retired Canton police officer was convicted of workers' compensation fraud, and a man was jailed after fabricating elaborate household fires to collect off of insurance. The newsletter, ZALMA on Insurance Fraud, then provides for a way you can make a gift to your vendors and to the insurers for whom you work without getting into trouble with their non-gift policies by providing books that will help them in their profession. By going to the insurance claims library at ZALMA.com and selecting either Kindle books or paperbacks from the list that can help any professional in the insurance world become more professional and more effective and can avoid or defeat insurance fraud because they know enough to recognize it when it happens. And you can also subscribe to ZALMA on Insurance videos, which are available at YouTube and at rumble.com. If you found this video to be useful to you and interesting, please subscribe to my YouTube channel and my Rumble channel and to the blog so that you can be made aware of future videos and blog postings. And thank you for your attention.